Hello people, today we are going to discuss a recent judgment given by our Honorable Supreme Court, that is, State of Madhya Pradesh versus R.D. Sharma. In this case, the question was whether equal pay for equal work is a fundamental right or not. So, we will see what the Honorable Court said in this regard. Here it is important for us to consider the rules, namely the Indian Forest Services Pay Rules of 2007 and the amended rules of 2008. So, let us start by understanding the facts of this particular case. Here, the petitioner was a retired and ex-government official, and he wanted his pension to be increased, pension to be revised from a sum of rupees 37,000 to 40,000. And in this regard, the respondent makes a representation to the Government of India to get his pension revised. But the said representation gets rejected by the government. Further, the respondent appeals to the Central Administrative Tribunal, and that appeal also gets rejected by the tribunal. Further, the respondent files a petition in the High Court of Madhya Pradesh, Jabalpur, and that petition was allowed by the court. And here the court held that yes, the respondent was eligible for the benefits of increased pension, that is rupees 40,000. Further with time, this was challenged by the state of Madhya Pradesh, and this matter moves to the Supreme Court of India. The apex court said that the High Court orders passed in the writ petition as well as in the review petition had thoroughly misdirected itself by applying the principle of equal pay for equal work after reliance on the decision of this court in the case of State of Punjab and others versus Jagjit Singh and others, which had no application to the facts of this present case. The court also noted that the equation of post and determination of pay scale is the primary function of the executive and not that of the judiciary, and therefore the ordinary courts will not enter upon the task of job evaluation, which is generally left to the expert bodies like the Pay Commission. And the court made mention of various precedents in which it was held that equal pay for equal work is not a fundamental right vested in any employee, though it is a constitutional goal to be achieved by the government. And hence, the apex court rightly rejected the claim of the respondent and said that the just and proper order of the tribunal was wrongly set aside by the High Court, and that they wrongly applied the principle of equal pay for equal work. The tribunal had not committed any jurisdictional error nor any failure of justice had occasioned, and hence the interference of the High Court in order passed by the tribunal was absolutely unwarranted. So finally, the order of the High Court was set aside, and it was said that equal pay for equal work is not a fundamental right, but it is a constitutional goal to be achieved by the government. Thank you.